Hello friends, in the series on income tax cases, today we will discuss a very important case in regard to imposing of penalty under section 271 subsection 1 clause C. And the issue before the Ahmedabad ITAT-A bench was that where the addition has been made in which there is a debatable issue or which involves very interpretative issues, so whether in that case whether a wrong claim made by the assessee can be categorized into furnishing of inaccurate particulars or concealment of income. This issue has been decided by Ahmedabad ITAT-A bench in the case of Deputy Commissioner of Income Tax versus Unimad Technologies Limited, and this case is reported in 135 ITR Tribunal short notes 38, and the date of the judgment is 3rd March 2026. The present case relates to the assessment year 16-17. In the present case, the assessee has made advance payment for the purchase of machinery outside India. The assessee has to incur a huge exchange loss on this advance payment made for the purchase of machinery outside India. The assessee claimed this exchange loss, this foreign exchange loss, as a revenue expenditure into his books of accounts. The assessee case was picked up for scrutiny under section 143 subsection 3, and when the assessment proceedings were going on and the assessee was show caused that why this amount should not be disallowed to the assessee said that since machinery has not been purchased yet, only the advance has been given, so it cannot be treated as capital expenditure up to this extent, so the foreign exchange fluctuation loss should be allowed to the assessee. On the other hand, the learned assessing officer was of the considered view that since the payment has been made for the purchase of the capital expenditure for the purchase of the machinery, so the foreign exchange fluctuation loss should be capitalized. So accordingly, the assessing officer disallowed the foreign exchange fluctuation loss. The CIT appeal, as far as the quantum appeal is concerned, gave the substantial relief to the assessee. After that, the assessing officer show caused the assessee for imposing the penalty for furnishing inaccurate particulars, and accordingly the assessing officer imposed the penalty, which penalty was related by the CIT appeal. When the matter was before the tribunal, because the revenue filed the appeal against the order of the CIT appeal in the tribunal said that by simply making a wrong claim in the return of income cannot tantamount to concealment of income or furnishing of inaccurate particulars as a straitjacket formula. The tribunal said that in the present case the facts are very clear that the assessee has disclosed all the facts in the return of income filed by the assessee for computing the return of income. The tribunal said that the facts of the case suggests that in the present case the issue is very much debatable and interpretative. In the case of the assessee, whether the foreign exchange fluctuation loss should be capitalized or claimed as revenue expenditure, the cases were both in favor of the assessee and both in against the assessee. So in that case, a very presumption can be taken that this is a debatable issue, and in case of debatable issue, the penalty should not be levied. It cannot be proved that the assessee has furnished inaccurate particulars. Friends, it has been seen that when the assessments are made, the assessing officers generally presume that penalty is to be levied on the assessee. This is the general, this is the intention. After the assessment proceedings, the penalty proceedings are different proceedings. Every case is not fit for penalty, but it has been seen that the penalties are being imposed, being initiated as a ritual because some additions have been made. So in the present case, it is a very classic case to understand that what are the cases in which the penalty should be levied or the cases in which the penalty should not be levied. If the assessee proves that the issues is debatable, so the penalty should not be levied in that case, because sometimes the income tax matters are so litigative that even the assessee or even the revenue do not know that whether this amount is allowable or not. So those cases are not fit for imposing the penalty. At the end of this video, once again I am repeating the name of the case, The name of the case is Deputy Commissioner of Income Tax versus Unimad Technologies Limited, and this case is reported in 135 ITR Tribunal short notes 38, and the date of the judgment is 3rd March 2026. Thank you, friends.